proceed for the DIFC. Our panel today is me. On my right, we've got Matthew Watson, we've got Jeremy Richmond, Casey, we've got Simon Oakes and Mike Rode. We'll tell you a bit about ourselves in a bit more detail. So I'm a partner at Trowers now, International Head of Dispute Resolution. I specialise in litigation and international arbitration, and in particular shareholder disputes, finance disputes, fraud, and asset tracing. I've been listed as a leading individual in the Legal 500 for the last decade, and I've worked in several of the DIFC courts leading cases over the last 4 years.
And worldwide freezing orders, so we'll talk about those cases later. Mike?
Thank you, Matt. Hello, everyone. Thanks for coming today. I'm Mike Rode, a partner in our commercial litigation team, and amongst other things, specialise in fraud claims and asset recovery and enforcement, and frequently work with Simon and Jeremy and Matthew on lots of interesting cases, many of which not actually looking at those cases today, but similar cases and similar experiences and touching on similar issues of law. So that's from me.
Matthew?
Hi everyone, I'm Matthew Watson. I'm a barrister at 3 Verulam Buildings. I've got a pretty broad commercial practice that covers fraud, banking and finance, company, insurance, insolvency. My practice is pretty neatly 50-50 divided between litigation in the English courts and litigation in the common law tribunals in the Middle East. So that's the DIFC court, the ADGM court, and arbitral tribunals that sit out there. So I'm fairly familiar with how things work out there.
Jeremy?
Good afternoon, everyone. Lovely to meet you all. My name is Jeremy Richmond. I'm a silk at Quadrant Chambers. I do most of my work in the London Commercial Court. I'm involved in one quite major fraud case in the ADGM at the moment, which is taking up a significant amount of my time this year and next. I split my practice between commercial chancery, often dealing with fraud, asset recovery, and shareholder disputes, and I do quite a lot of cross-border insolvency as well.
Simon?
Hello, I'm Simon Oakes. Like Jeremy, I'm at Quadrant Chambers, and like Jeremy and Matthew, I specialise in commercial fraud. I started out doing lots of the banking scandal cases from around 2010 onwards, and so all of my cases for quite a while have had some element of skullduggery and wrongdoing in them, albeit now with fewer bankers and more international fraudsters.
So today we're going to talk about freezing orders in support of foreign proceedings, and principally how the DIFC court now approaches the issue as a result of the recent Carmen case, and how the English court approaches the issue as a result of the recent MEX Group and GFH cases. We'll then talk about cryptocurrency updates and Norwich Pharmacal orders. So the first case is the Coffee Planet and Jones case, which is a case of mine about freezing orders. Before I deal with that case, I'm actually going to jump ahead to the next slide, which is the Sandra Holdings case, because those cases tic-tacked with one another and the chronology jumps about a bit. So Sandra Holdings came chronologically first out of the 2 cases. That was a case of an ultra-high net worth Kuwaiti individual against other members of his family. We acted as the claimant. His case was that $200 million in assets had been diverted out of a family investment vehicle. There, the underlying substantive proceedings were on foot in France and Kuwait, and there was no material connection to the DIFC. Nevertheless, it was argued that the DIFC court has an underlying jurisdiction to offer support for proceedings taking place in other jurisdictions. However, it had never been established before that the court would use that jurisdiction to grant worldwide freezing and asset disclosure orders to support proceedings taking place in another overseas jurisdiction. We applied to the DIFC court for both a freezing order and an asset disclosure order to support the underlying substantive proceedings that were taking place in France and Kuwait. We successfully persuaded the court to grant that order. This was therefore a critical case in developing the jurisdiction of the DIFC court to grant such orders because, at least as far as we were aware, they'd never granted such orders before. Having persuaded the court to grant the order in the Sandra Holdings case, shortly after that, we were then instructed on the Jones and Coffee Planet case, And we were able to then use the work that we'd done in Sandra Holdings as a springboard to support what we wanted to do in Coffee Planet and Jones. So Coffee Planet and Jones was one of the most bitterly fought bits of litigation that I've been involved in my career. We acted for the claimant. That was a case for an ultra high net worth individual against his son. In that case, my client alleged that his son had diverted $30 million worth of assets out of a family investment vehicle. In that case, the underlying substantive proceedings were taking place in onshore Dubai. And again, there was no real connection to the DIFC. There's a significance there because some of you in the room will know the distinction between onshore Dubai and the DIFC, but they're separate jurisdictions. So similar to in Sandra Holdings, it had never been established before that the DIFC court would use its underlying jurisdiction to offer support for proceedings taking place in onshore Dubai. So again, we applied to the DIFC court for a freezing order and a disclosure order to support the proceedings that were taking place in onshore Dubai. Again, we successfully persuaded the DIFC court to grant that order. And again, as far as we're aware, that was the first time they'd granted such an order. So it was another critical case in developing the DIFC court's jurisdiction. Having won the Jones and Coffee Planet interim applications, the respondent in Sandra Holdings then appealed the court's decision in Sandra Holdings and took it to the DIFC Court of Appeal. Oops, going the wrong way, sorry. So back to slide 8. So in Sandra Holdings, having got the freezing order and the asset disclosure order, the respondents breached every aspect of that order. They just ignored it. We then applied for them to be held in contempt of court, and the DIFC court applied enormous fines and penalties to them and referred the matter to the Dubai public prosecutor to initiate criminal proceedings against them. That was then the trigger for them appealing to the Court of Appeal because they didn't want the underlying criminal proceedings to take place against them. However, in that case, the Dubai Court of Appeal then ruled that they'd gone too far at first instance and arguably in Jones as well and reversed the decision. So that decision on appeal called into question the entire line of authority that had been developed as a result of Jones in the first instance Sandra Holdings case. However, then in the following case, which was the Carmen case, the DIFC Court of Appeal reconsidered the position and went back more or less to the position in Sandra Holdings at first instance, where they held that they did have jurisdiction to issue worldwide freezing and disclosure orders in support of proceedings outside of the DIFC. So in Carmen, the court held the following. 1, that the court had jurisdiction to recognise and enforce foreign judgments. 2, that it had jurisdiction to issue freezing orders in support of pending foreign proceedings and before a judgment is issued. And 3, wrong slide, sorry, that there is a power also for the court to issue such a freezing order. Now, that's an important case because one of the DIFC court's main selling points is that it has credentials as part of an international network of commercial courts who want to cooperate with each other to support one another's proceedings in judgments and try and assist claimants that are pursuing defendants for money that they say they owe them. And obviously the Sandra Holdings case went against that reputation and the kind of previous line of authority that the court had been trying to develop. So actually going back to that in the Carmen case was very important, not only on a practical level as practitioners, but also for the court's reputation as part of a global network of courts that support one another. And clearly the ability to grant freezing order to support foreign proceedings before judgment is issued is a key part of that. Mike, next.
Thanks, Matt. Can I have the clicker?
Yeah, although I can click if you like.
Hopefully it still works over here. Thanks very much. So I'm going to talk or introduce at least the MEX Group case, which is Court of Appeal judgment in England. Interesting for lots and lots of reasons, but not only for the law, but the sort of factual background behind it, a sort of classic tale of allegations and counter allegations of frauds and misdoings, as it were. So just as it says on the overview section of the slide here, this case considered the circumstances in which a freezing injunction under Section 25 of the Civil Jurisdiction and Judgments Act 1982 could be made by the English courts in support of foreign proceedings. The Court of Appeal, amongst other things, focused on the inexpedient limb of the test under Section 25, where, importantly, the defendants were not resident in England and they had no assets here. And the main question that they looked at in that context was whether the court needs to find a connection with England and Wales before making a worldwide freezing order under Section 25. So just firstly, looking at the key principles, Section 25 of what I'll call the CJJA plus CPR 25(1)F Roman numeral 1 and CPR 25.4(1)A give the English court the power to grant interim relief in aid of actual or intended substantive proceedings taking place in any jurisdiction in the world. And the question that the court will ask itself when applying that test, firstly, would relief, i.e. worldwide freezing order or Morava relief, have been granted if the substantive proceedings had been brought in England? And then once they've dealt with that question, we'll then look at their exercise of their discretion, and the court will ask itself whether it would be inexpedient to grant relief because the court has no jurisdiction beyond Section 25 itself. So just looking quickly at the facts before turning to the law, which Jeremy will look at once I've had a look at the facts. The claimant was MEX Group, which is a Hong Kong-based company, for Multibank, which is a group of derivative trading platform companies, as it says at the first bullet there. MEX Group brought a claim in Scotland, claiming that 12 defendants had engaged in a complex unlawful means conspiracy against it by causing one of the defendants, the 11th defendant, MEX Securities, to renege on a particular agreement. I won't look at all of the defendants, obviously a lot of them aren't particularly relevant for present purposes, but the first defendant was a Mr. Stuart Ford, who is, as it says on the slide there, notorious. So notorious, in fact, that, as Lord Justice Mayles explained, Mr. Ford has the unenviable distinction of having been fined £76 million by the Financial Conduct Authority and prohibited for life from being engaged in activities regulated by it. He appealed unsuccessfully against that determination and was found by the upper tribunal to be a man whose conduct demonstrated a consistent failure by him to act with integrity, who consciously and deliberately set aside his regulatory responsibilities in pursuit of entrepreneurial ambition, and whose actions were driven by his desire to maximize and preserve financial gain for himself without regard for the impact this would have on investors and so on and so forth. So an interesting character, to say the least. He's not central to the Court of Appeal's decision, but he is contextually relevant to another one of the defendants, Mr. Smith, who I'll come on to in a minute. The 11th defendant was MEX Securities. The 4th defendant was a German national, Mr. Gollitz, and the 9th and 10th defendants were German and Luxembourg companies, respectively. But the important point here being that none of them had any assets or any presence in England and Wales. So just turning on further to the next slide. So the factual context for the claim was MEX claimed that it had lent money to MEX Securities, but the 4th defendant, the German national, Mr. Gollitz, had withdrawn funds from loan notes issued by MEX Securities, and that this had breached some prior assurances and gave rise to a BVI claim against MEX Securities, which indeed was commenced. Then things become a little bit murky, and there was an agreement apparently reached in Dubai by MEX Securities, who were represented at that time by the 3rd defendant, Mr. Colm Smith, who was a friend of Mr. Ford. And that agreement was to immediately settle the BVI proceedings by paying MEX Securities, paying MEX Group 36 million euros, and that was recorded in a BVI consent order. The MEX Group said it was a genuine agreement, but the defendants here said that it was all a fraud, it was all a sham designed to extract monies from MEX. And shortly after the agreement was reached, they reneged on the agreement and said that Mr. Smith didn't act for them and had no authority to act for them. Subsequently, litigation ensued in various guises. So MEX Securities then commenced proceedings in Luxembourg, alleging that Mr. Smith had apparently been held in a golden prison and not allowed to leave his hotel until he put pen to paper on this so-called agreement. But MEX Group successfully applied to have that suit stopped by the English court. The 10th defendant, in response, then intervened in the original BVI claim and sought to recover the 36 million, which they said had been paid over unlawfully, and managed to get a without notice freezing order against Mex Group, followed by which was continued on notice. Then Mex Group responds in kind and commences proceedings in Scotland, and alleged unlawful means conspiracy against the 12 defendants. Mex Group alleged further that Mex Securities had unlawfully reneged, had made false allegations about settlements, and that there had been a so-called inducement payment backing up that reneging of the agreement. Mex Group said they had a claim accordingly of 85 million euros for loss of profits and damaged reputation. Certain without notice orders were sought in the Scottish proceedings, sort of equivalent to domestic freezing orders and search orders. However, Mex didn't seek a worldwide freezing order in Scotland, because although the Scottish courts have the power to make such orders as a matter of policy, they don't do so. So Mex Group came to the English court and at a without notice application in front of Mr. Justice Lavender, got the worldwide freezing order. But then at the return date hearing, the 3rd, 4th and 10th defendants successfully managed to have the worldwide freezing order set aside. Deputy High Court Judge Tinkler held that Mex Group, that there was no real risk of unjustifiable dissipation, that it would be inexpedient to grant worldwide freezing order because there was a lack of connection to England and Wales, and there had been a failure to provide full and frank disclosure. Quite frankly, the failures were extensive and quite serious. Mex Group then appealed to the Court of Appeal, which is the focus of the judgment which Jeremy's going to be looking at presently. And they said, well, no, that's wrong. There was a real risk of unjustified dissipation. Mex Group also argued that the lack of connection to the jurisdiction does not render a worldwide freezing order to be inexpedient, and argued in connection with that the previous requirement for there to be a connecting link to the UK was actually established under EU law, and as a result of Brexit, that had fallen away and no longer applied. And they subsequently also argued there had been no lack of full and frank disclosure. I think there I'm going to hand over to Jeremy.
Thank you, Mike, for that very clear summary of a rather factually complicated case. And thank you, Mike, and also to Matt Schaller for arranging this talk and hosting this event, and your fantastic offices here in the City of London. When I was invited by Matt and Mike to speak on this session, To Catch a Thief, it prompted me to rewatch a famous Hitchcock film of the same title. I must confess I've not seen it since my university days, which sadly were rather a long time ago now. For the benefit of those who have not seen the film, the pilot involves John Roby, played by one Cary Grant, as a retired cat burglar who has to save his reformed reputation by catching an imposter, John Williams, who is preying on wealthy tourists on the French Riviera. One such tourist being Francis Stevens, played by very young Grace Kelly. John Roby's, Cary Grant's flirtatious relationship with Francis Stevens, Grace Kelly, lies at the heart of the film. A line from one of the most famous scenes in the film is as follows, and I shall not try to mimic Cary Grant's rather peculiar mid-Atlantic accent. Francis Stevens, Grace Kelly, I've never caught a jewel thief before. It's stimulating. It's like John Roby, Cary Grant, like sitting in a hot tub. I slightly disagree with Cary Grant's sentiment. One of the most stimulating parts of practice in England and elsewhere is the location of assets to secure our clients' assets, or at least to prevent misfeasant parties from dissipating his or her assets pending judgment being obtained in favor of our clients. In deference to those who have not seen the film yet, I shall not give away the twist in the plot in which the actual thief is caught. But the film does evidence the difficulty in identifying, firstly, the actual thief, and secondly, locating the goods he or she has stolen in the context of a relatively straightforward mid-20th century Hollywood plot device. Perhaps sadly, life has become more complex, but happily, English law provides a very wide-ranging array of remedies to assist those seeking interim relief here in support of foreign proceedings. One such remedy is the English court's relatively long-standing willingness to give interim remedies in support of foreign proceedings by way of Section 25 of the Civil Jurisdiction and Judgments Act 1982 as amended, or the CJJA. Mike's touched briefly upon the very broad summary of what it provides, but let me drill down a little bit to what it precisely provides. In general terms, Section 25 of the CJJA gives the court power to grant interim relief. The section is headed, helpfully, Interim Relief in England and Wales and Northern Ireland in the absence of substantive proceedings. Section 25(1) provides that it applies to instances where proceedings have been or are to be commenced in a 2005 Hague Convention state, and, that's conjunctive, they are proceeding whose subject matter is within the scope of the 2005 Hague Convention. The scope is pretty widely drawn, but excludes things like the arrest of ships or the like. Pausing there for 1 second, a slight trap for unwary for those coming to this section for the first time. Since the 1st of April 1997, by statutory instrument, Section 25(1) of the CJJA was amended so as to allow the English court to grant interim relief in relation to foreign proceedings not taking place within the relevant Hague Convention state. So for those of you who mourn the days of looking at rather obscure and densely drafted treaties, that's bad news for you, happy news for the rest of us. As Mike mentioned briefly, the critical part of the Metz Group case turned on the meaning of Section 25(3). I'm going to read what that says. On an application for interim relief under subsection 1, the court may refuse to grant relief if, in the opinion of the court, the fact that the court has no discretion apart from this section in relation to the subject matter of the proceeding in questions makes it inexpedient for the court to grant it. Just pausing there for a second, as Matt Schauer accurately said, and Mike as well, what's clear from this provision is that it's discretionary. The word may is front and center. The phrase inexpedient is a slight will-o'-the-wisp in the sense that one would have thought it would be quite easy to determine whether something is inexpedient or expedient. Sadly, that's not the case, and the phrase carries rather a lot of case law over the number of years the CJJA has been in play, in force. The expediency test is the one aspect I'm going to focus on for the remainder of my talk. Given I only have about 7 or 8 minutes, I'm told that I'm going to be thrown out of the building when I go over, so I shall try to behave. There are other aspects which I put down now for discussion, maybe over coffee after the talk or in Q&As. And on that point, if it's a difficult question, please direct it to my co-panelists. Easy ones I'm happy to take. But the 3 aspects I'm not going to talk about today are firstly, full and frank disclosure, which is always a vexed topic for all of us working in this area. And Stephen Mayles, or Lord Justice Mayles, I should say, has quite a lot to say about that. Observations, secondly, observations on why there is no longer a need to establish a cause of action, which can be sued in England and Wales, an interesting topic, but one which the Court of Appeal found to be wholly irrelevant to the Metz Group appeal. And thirdly and finally, the weight to be attached to interlocutory foreign judgments. They are touched upon in my slides, but I just don't have time to do all of them. But as I say, I'm happy to discuss them in the Q&A or coffee afterwards. So, turning to the first slide, the main points from it are as follows. There's still a need to show foreign proceedings would have warranted relief if the substantive proceedings were brought in England and Wales. So in simple terms, if you show the real issue to be tried, risk of dissipation, and just and fairness, then you get over that hurdle. Interestingly, in Metz, the Court of Appeal overturned the judge at first instance, but that was only because from the time of the first judgment to the appeal, new documents had come to light in Scotland that showed pretty squarely that the misfeasant defendants had been dishonest, and therefore it was quite easy to show risk of dissipation. So once you show, for the purpose of Section 25, that there would be Mireva relief in England if the matter, the foreign proceeding had been brought in England, the main issue in this case becomes one of whether or not the relief sought is expedient or not. And I'm going to refer, if I can, to the second half of this first slide, just to summarize where the issue lay when it came before a very powerful Court of Appeal. The claimant submitted that the need for a connection with England and Wales had been swept away by the broad idea. That was the case that established that you no longer need to show a course of action in the jurisdiction to get a freezing order in England, and by Brexit, and that the court should have broad discretion to grant an order even absent the connecting link in England. So the key point when you cut through the legal factors is that the claimants were trying to say there was no need to show a connecting link with England. The defendants argued that the injunction should only be granted if a defendant has connection with the jurisdiction of England and Wales as a result of being domiciled or resident here, or as a result of having assets here. The position before the broad idea was relatively straightforward as far as most of us practitioners were concerned in any event. And I'm going to just rattle through these relatively quickly. It is really appropriate to exercise jurisdiction to grant a freezing order where the defendant has no assets in England and there's no allegiance in England's court. Protective measures best left to courts where assets are to be found, or where D resides, or where a foreign court has imposed certain jurisdiction. To use the kind of quite hackneyed phrase, we, i.e. the English lawyers and the courts, are not the international policemen of the world. And that's always a line trotted out against me when I try and get Section 25 injunctions, but I just mention it because you will come across it if you haven't done one of these applications yet. The domestic freezing order, often appropriate where the defendant has assets within the jurisdiction. And then finally, most critically for 4, where D is not resident and the court lacks in persona jurisdiction, the court would only grant freezing order relief under Section 25 if there is a real connecting fact link between the subject matter measure sought and the territorial jurisdiction of English courts. And cases one where from a primitive perspective, it's appropriate for the court to act, is not appropriate for the court to act as an international policeman. I just mentioned that. There are a number of factors which I haven't got time to go to, which are flagged in the Motorola case at paragraph 115. In summary, the decision of the Court of Appeal was interesting. It basically rejected the claimants and the appellant's argument that the defendant's argument, I beg your pardon, that the connecting factor had been swept away by Brexit and the convoy case, and doubled down on the need to show a connecting link. I'm just going to briefly touch upon some aspects of this slide here. The first point is that the summary in the second bullet point is pretty accurate. The courts consider whether a granting Section 25 freezing order is inexpedient for lack of other jurisdiction in the court, or there has to be a connecting link with the territorial jurisdiction of England, and it must be shown against each of the defendants. But one must bear in mind that, leaving aside the re-emphasis of the need to show a connecting link with England, the courts can, and often do take a generous view on what the connecting factor might be. On the facts of this case, it was clear there was no connecting factor. I think only one of the defendants actually came to England now and again for business trips. There was no connection with any of the other defendants to the jurisdiction. But, and this is a very big but, you can argue that in some instances, that if the defendant has used an English solicitor's firm as his agent in a scheme to conceal assets which he has stolen, and the courts find that the solicitors can practically be ordered to give information about what has happened to those assets, that in itself might be a connecting factor. That's the case of Republic of Haiti versus Duvalier, which is a case of long standing from 1990, but it was expressly considered by the Court of Appeal in the Mex Group case and was approved. So it comes up close to the line, but it's a fair point that if your defendants have some legal representation in England, that might be something to be worth looking at to try and establish a connecting factor and thus justify some relief in this jurisdiction under Section 25. So the connection factor, while on its face is quite a hard bar to surpass, with some creative legal thought, it might be said to be more easily surmountable than it might otherwise appear. England and Wales still is, in my view, a good jurisdiction in which to catch a thief.
Thank you very much to the microphone technology, first of all. Thank you very much to Jeremy. Thank you very much to Trowers for having me, and thank you to all of you for being here. Over the next 7 minutes, I will be discussing the construction of orders discharging freezing injunctions and practical issues to watch out for. That's a case of GFH and Hague. We'll be discussing the law of immovables in the Kuriva case, and cryptocurrency as property in Deloya, as well as Howl on the nature of Bitcoin. I'll then be dealing with every entry in the Encyclopedia Britannica and digressing briefly into the meaning of life. And so, as you will anticipate, this is going to be a very deep dive into each of those topics. So beginning, first of all, with GFH and Hague. This concerned Mr. David Hague, who was formerly the managing director of Leeds United, latterly the deputy CEO of a financial services firm in the DIFC, thereafter a guest of the Dubai authorities in prison there. And it would be fair to say the last 10 years of his life have not been particularly pleasant. He was accused of embezzling about 5 million in false invoices and paying the way to himself. GFH commenced proceedings in the DIFC and got a worldwide freezing order there. And an English domestic freezing order was sought with a Part 8 claim form. And a freezing order was granted here in support of those DIFC proceedings using the methodology in Section 25 of the 1982 Act that you've just heard described. And in that English order, Mr. Hague was restrained from dealing with his assets in England and Wales until the disposal of the claim, capital C, or further order. And the question in this case was about what on earth that meant. Did the injunction expire on the disposal of the DIFC proceedings that it was designed to support, or did it continue until the English Part 8 proceedings, in which the injunction was granted, were terminated? And the wording of the order pulled in different directions. It was a Part 8 claim form, it had a claim number, but the previous sentence to the one this order was contained in referred to the claim in the DIFC. So what on earth did it mean, this capital C claim? And that was the rather narrow question that went up to the Court of Appeal. And this case is interesting for two reasons. One, it restates the principles. If you yourself have a similarly ambiguous court order, this is a good place to go to be reminded that the sole question is what the order means, not what it should have meant, what it should have been. And the words of the order, unsurprisingly, are to be given their natural and ordinary meaning and construed in their context. The reasons for making the order and the issue to be resolved as set out in the judgment will always be admissible as aids to construction. But of course, an order for injunction should be construed restrictively. Now, there was a difference of opinion in the Court of Appeal. I'm not going to go into that in a great deal of detail, but what was held by the majority, Lord Justices Peter Jackson and Phillips, was that the order, the claim in question was the DIFC proceedings, that the freezing order stood discharged when the foreign court delivered a judgment on the substantive court, on the substantive claim. And the factors included the ones I've put on the slide, in particular, that basically there wasn't anything else that would happen in the English proceedings. There was no further claim to proceed to disposal. And so, for example, the words costs in the claim must, the majority thought, have been a reference to the foreign proceedings, because otherwise there would be no further event in the English proceedings that costs could follow. So that's what they decided. But the case is, I think, a little more interesting for the practical guidance that comes out of that. And part of it comes from the dissenting judgment of Lord Justice Arnold, who's obviously been in a disagreeable mood because he also dissented in the next case, which I'm going to come on to. But the point here really is to be vigilant about events discharging freezing orders. Lord Justice Phillips, I'm so sorry, I've obviously skipped ahead too far on the slides. Lord Justice Phillips said that the courts require a claimant availing itself of the nuclear weapons of civil litigation to monitor actively their use and effect, and to be astute to apply to the court to maintain their effectiveness and fairness. And so, of course, in this kind of a situation where you've got an English freezing order that can be discharged upon the happening of an event in foreign proceedings, you could well imagine a scenario where a claimant in foreign proceedings succeeds, gets a big judgment, and thus automatically and at the same time, their English freezing order protecting assets in England disappears in that moment. Now, that's no problem if you know what's coming, if you've had notice of a hand down of a judgment, for example. When hand down is imminent, go off to court quickly and get an order for a continuation or indeed a fresh order. But you must, of course, beware of extempore judgments or written judgments being handed down without advance notice. And that was one of the things that really troubled Lord Justice Arnold. Now, those are factors which arise, of course, all the time in domestic proceedings, but it is much harder to keep an eye on those kinds of things if there is a massive time difference. If you've got an order in Singapore that might be handed down in the night here or likewise in America, then it is much harder to keep on top of that. But this case is a reminder that you must do that. So the next case, Kariva and Bedsamov. This concerned a property in Belgravia owned by a Russian resident in the UK, Mr. Bedsamov. He was declared bankrupt by a Moscow court who appointed Ms. Kariva as the trustee in bankruptcy. And under Russian law, in fact, much like English law, the property formed part of Bedsamov's bankruptcy estate, Russian law, and it vested automatically in Ms. Kariva as his trustee in bankruptcy. In 2021, Ms. Kariva applied to the English High Court for recognition of that bankruptcy order at common law, because there were no relevant bits of statute to assist, which we'll come on to, and for an order vesting that London property to her possession and control, what they described as an entrustment order. Meanwhile, a worldwide freezing order had been granted for over £1 billion against Bedsamov and his assets in the worldwide freezing order granted in England against Bedsamov's assets, but he got a variation of that, including to allow him to sell this property to pay his lawyer's fees. And so Ms. Kariva was seeking an order recognizing the bankruptcy order, vesting the property in her, and seeking to set aside that variation, which was allowing Mr. Bedsamov to sell his Belgravia property. And basically what she said was that she was entitled to that property simply because of the Russian bankruptcy order. And that ran slap bang into the immovables law, a rule of private international law. And the basic idea of that is that questions about rights in respect of land and other immovable properties are governed by the law of the country in which that property is situated. And therefore, a foreign court does not have the power to make orders in respect of English land and interests in it. And those rights are exclusively governed by English law. And so that was the decision in this case, that far from automatically vesting the property in the bankruptcy trustee, as Ms. Kariva sought, the order of the Moscow court did not convey any interest at all in the London property. And therefore no recognition would be given to the part of the Moscow court order which purported to affect the rights in the London property. And therefore the English court had no power at common law to deprive Mr. Bedsamov of his interest in the English land in favor of the foreign trustee in bankruptcy. Now, it would have been different if statute had provided for some protection under Section 46 of the Insolvency Act, if the property had been, if the bankruptcy had been taking place basically in a Commonwealth country. It would have been different if the cross-border insolvency regulations of 2006 had applied, because the bankruptcy was happening in Mr. Bedsamov's centre of main interest. It would have been different, but it wasn't, because his main interests weren't in Moscow anymore. And so neither of those things applied. And it would have been different if, instead of trying to use the Moscow order and bringing it over to London and seeking to use that to get hold of the property, Ms. Kariva had just applied for a bankruptcy order in London, then that would have been different as well. But the way they did it, of trying to, in effect, use the order of a foreign court to get hold of English interests and property, that did not work at common law because of the immovables rule. Now, cryptocurrency. Case of Deloya and BitCub, and I will take this briefly, not least because I think that junior counsel for Deloya is in the room and will know vastly more about it than I do. But the key point to take away from this case is that it is a reiteration that cryptocurrency, that crypto assets, or at least Tether, the particular secure coin involved in this case, are property, third kind of property. And it's also a case where, should you be interested in the arcanery of tracing and following, as well as issues of expert evidence and pleading, it is worth a read. But factually, the key points were that these were claims in unjust enrichment and constructive trust brought against a Thai cryptocurrency exchange, BitCub. And basically 2.5 million worth of the Tether stablecoin had been transferred there as a result of fraud perpetrated by persons unknown, and there followed a cryptocurrency laundering operation where the currency hopped about 14 times on the blockchain, rather the layer on top of the blockchain, and the funds were ultimately extracted in Thai baht. And the claim failed because the claimant had failed to evidence that the Tether had actually reached the BitCub wallet. But the point for interest today is that this is the first trial addressing the status of crypto assets. And so Deputy Judge Farnhill concluded that crypto assets, such as Tether, are not a shows or a thing in possession, i.e. a thing that can be physically possessed. They're not a shows in action, a thing that can only be claimed through legal proceedings, a Hofeldian claim right, that's often known, but that nevertheless, Tether attracts proprietary rights at English law. And that chimes with the Property Digital Assets Bill currently making its way through Parliament, that a thing will not be defined, will not be denied recognition as property just because it's not one of those two traditional classes of property under English law. So a further reassertion about trial that crypto assets are property, or at least Tether is property. Then a lot of analysis of tracing and following, remembering, of course, that following it involves the same asset passing from hand to hand. And the interesting thing about this case is that Tether, being a uniquely identifiable form of property, probably could have been followed from hand to hand. Tracing, of course, where you have one form of property being exchanged for substitute forms, more usually it is seen in cases of bank account transfers. But that following in this case could have worked had the expert evidence backed it up. And then there's a lot about unjust enrichment, constructive trust, and knowing receipt. And there's also a salutary tale about the expert evidence coming up to proof and what happens when the experts let you down. Finally, it used to be the case that Jimmy Kimmel, when he hosted his Jimmy Kimmel Live show, would get to the end of his bit and say that I'm very sorry we haven't had time for Matt Damon. And I was tempted. Matt Damon never appeared on the show, I think. I was tempted to do the same with Howells and Newport, but I will do it very, very briefly. This is the case about keys to Bitcoin ending up in landfill. And I won't do it at any length. But the interesting point, you'll all be familiar with this case about poor old Mr. Howell, who had the record, the key to his Bitcoin account, which now is worth about £600 million on a hard drive, and his partner threw it in the landfill. And the question was whether the council had to fish it out. And the short point is that no, they don't, because basically once you put something in landfill, it belongs to the council, it is their property. But the interesting feature of the case from the point of view of Bitcoin and other crypto assets are that property within this third category, not shows as in action, not shows as in possession, have no location. That at best, what is on Mr. Howell's hard drive is the record of his digital key. That is information, it's not property. And so that the hard drive is property and it now belongs to the council. I'm afraid I have run out of time to deal with every entry in the Encyclopedia Britannica and the meaning of life, but hopefully there'll be another occasion to deal with those. And on that note, I will pass over slightly beyond my time with apologies to Matthew.
So we're going to talk about Norwich Pharmacal orders, and foreign proceedings now. So Matthew, we're going to be discussing this issue and how that relief can be used to aid foreign proceedings. There have been some developments in the DIFC, which you'll come to later, but perhaps you can start by summarising the position in England.
Sure. I don't know whether this makes me Matt Damon. Hopefully that'll make this slightly more interesting.
You're better looking.
Thank you. Thank you. That's in the script. The story in England is a tale of two parts because, as you probably all know, the modern Norwich Pharmacal jurisdiction originates from the eponymous decision in 1974. And at the time, the jurisdiction was focused on compelling people to provide information about wrongdoers, although that was expanded out into the provision of documents, probably the most famous subset of Norwich Pharmacal order, the Bankers' Trust, where the bank is required to provide information and documents about bank accounts that have been used as conduits for fraud. Often, in addition to just ordinary bank material, you're getting KYC information and things like that. But what's interesting about the use of these kind of orders in support of foreign proceedings is that very shortly after Norwich Pharmacal in 1974, Parliament passed the Evidence Proceedings in Other Jurisdictions Act 1975, snappily titled, which provides a regime under which foreign courts can request the English court's assistance in taking evidence through letters rogatory. I don't know how many of you have ever had the fun of doing one of these. They are very slow, they are very cumbersome, painful for the lawyers. Obviously, they depend upon proceedings having already been instituted in the foreign court. That's a problem if you haven't identified your wrongdoer yet. And using the 1975 Act often means the wrongdoer is getting notice of what you're doing. So unlike in Norwich Pharmacals or freezers when you can obtain things ex parte, under the 1975 Act, the wrongdoer usually knows precisely where you're looking. And in one of the first decisions on the 75 Act, Lord Diplock in the House of Lords in a case called Rio Tinto said that the powers of the English court to aid a foreign court in taking evidence were exclusively statutory. Now, far be it for me to disagree with Lord Diplock, but the basis for that proposition is not entirely clear from his judgment. It's in the opening paragraph, and he just states it. What is interesting is that that remark went completely unnoticed in the context of Norwich Pharmacal orders. So what you've got was a series of cases, and I put three of them on the slide, SmithKline, Omar, Schleimoon, where the English courts were perfectly happy to make Norwich Pharmacal orders expressly on the basis that the respondent is going to be providing documents to aid proceedings in a foreign court rather than in England. And indeed, SmithKline is a decision of the Court of Appeal, and none of the Lord Justices in the Court of Appeal thought that there was anything controversial about that. But I said it was a tale of two parts. The second part is the discovery that perhaps this jurisdiction might not be as broad as everyone thought it was. And in 2013, there was something of a change of course with the decision in Ex parte Omar and the Secretary of State. Bit of an unusual claim, that, because the claimant was seeking Norwich Pharmacal relief through judicial review. And he was seeking Norwich Pharmacal relief from the Foreign Secretary because he alleged that he'd been rendered unlawfully to Uganda, and he wanted to use that material in support of criminal proceedings that were being brought against him in Uganda. And the Court of Appeal refused to grant the Norwich Pharmacal relief and said that, and the reason why was because there's a statute called the Crime International Cooperation Act 2003, which sets out a statutory regime for providing evidence to foreign courts for use in criminal proceedings. And the court said, well, the existence of that statute excludes the common law remedy through Norwich Pharmacal proceedings. There was some obiter comment by the Court of Appeal about Norwich Pharmacals in civil proceedings, but this was a decision on the use of materials in criminal proceedings. And an important feature, I think, of Omar that's overlooked is that the 2003 Act dealing with crime contains provisions that allow ministers to restrict the disclosure of material for use in foreign proceedings on various discretionary grounds. And so one can see why a common law power like Norwich Pharmacal might be excluded if it's going to transgress on what who Parliament has said gets to decide what material goes overseas to support foreign criminal proceedings. Now, Omar was used as the basis of the decision in Ramelos, which I'm sure most of you know, the decision of Mr. Justice Flo, as he then was. And he held that the existence of the 1975 Act on Taking Evidence precludes the English courts from granting Norwich Pharmacal relief in support of foreign proceedings. The result of that decision is that the Norwich Pharmacal, as a tool of aiding claimants who are trying to chase fraudsters across the world, is very significantly diminished. The decision is now almost a decade old. It has never been considered by the Court of Appeal, but it is, I think, undoubtedly treated as the law in this jurisdiction. It was followed very recently in a decision, Green and CT Group. The Green there is Linda Green, the wife of Sir Philip Green, the former Topshop owner, who was seeking to use an MPO to get material for some proceedings that she was bringing in Guernsey. The English court said no. Ramelos holds we can't use this power to compel someone to provide documents for use in foreign proceedings. So that is where we are in England.
So I might be able to guess where this is going now, Matthew, but I'm assuming the DIFC court hasn't taken the same approach.
That's right. In last July, I obtained a Norwich Pharmacal order against a bank in the DIFC. The claimant was SCAT, who probably needs no introduction. I'm sure everyone here is familiar with the, I don't know whether I need to say fraud or alleged fraud, as Mr. Shah has been convicted in Denmark. The conventional issues on the Norwich Pharmacal were relatively anodyne. SCAT said, well, some of the money that was stolen from me has passed through the bank, and I want to know whose accounts they are. I want your KYC records, and I want to see what's happened to my money. And so an application was made, and the application was quite explicit that SCAT wanted to use the documents that had been that it would obtain for proceedings outside the DIFC, in onshore Dubai and in London. And on that application, we were met by Ramelos.
So Matt, sorry for interrupting, but Ramelos couldn't bind a DIFC court judge, could it? So how was it deployed?
It can't bind a DIFC court judge because it's just an English authority. But what is interesting is that when the DIFC's rules were prepared, somebody, and I have to be careful here because one of the draftsmen is sitting in the audience, but somebody basically copied the Evidence Proceedings in Other Jurisdictions Act 1975 and inserted it into the DIFC court's rules. For the nerdy amongst you, it's rule 30.65 onwards. So the Act exists in DIFC law as part of the procedural rule. So the argument was, well, there is a regime that covers the provision of evidence in foreign proceedings, and therefore the DIFC should adopt the same approach that had been adopted in England and treat the common law remedy as having been excluded where it's sought in support of foreign proceedings. Sir Jeremy Cook was not persuaded by that. He gave three answers. His technical answer, if I could call it that, was that the court's power to grant injunctions, and a Norwich Pharmacal is just a species of injunction, is a statutory power. The statute is unfettered, and a mere procedural rule can't affect the scope of the court's jurisdiction to make these orders. It could only ever go to discretion. But somewhat more powerfully, he gave what I think of as a sort of policy answer, and I've actually extracted it on the slide. He said, where international fraud is concerned, it behoves this court to assist the courts of friendly foreign nations in doing justice, and for that purpose, on the application of alleged victim of such wrongdoing, to enable the foreign court to have before it the maximum information available for it to make its own determination. I think that's quite a different attitude to the one that you would find if you went down to the Rolls Building today, where there is a somewhat conservative attitude to the use of the powers of the English courts to aid overseas courts. And this is the DIFC court saying quite expressly, we are here to help. And if there's some aspect of your fraud that falls within our jurisdictional purview, we will do all that we can to help you out. His third answer was even more interesting, because he said to my opponent, imagine that you're right and that the rules are a statutory regime that might arguably exclude the Norwich Pharmacal. I am not going to follow Ramelos, which Sir Jeremy described as, quote, uncommercial and not in accordance with the principles of comity. And he noticed all the things that I said at the outset, that the letters rogatory approach are slow, put the fraudster on notice, and as he said, often requires such a level of specificity in identifying documents that it's no use at all. That is, I think, powerful stuff from an ex-head of the English Commercial Court. So the result in the DIFC is that whilst English courts may not be much help for those litigating in the DIFC, if you're in England and you think a fraudster has moved funds through a bank in the DIFC or a bank over which the DIFC court has jurisdiction, and there is a difference, there is now the possibility of tracing that money and using the material in England. And since this decision came out in July, I've had a number of calls from firms who are representing victims of authorised push payment frauds, because very sadly, quite a lot of the money that's extracted out of people in England gets routed through banks in Dubai. And this now shows a way to trace some of that money and identify the real wrongdoers behind it. I think that's a very interesting development for everyone who's in this room.
So, Matthew, you've covered the position in England and the DIFC. Has this issue arisen anywhere else?
It has. I put a load of cases on the slide. The slide. The first three are from Guernsey, Jersey, and the Isle of Man. They have a statute in almost identical terms to the 1975 Act. In all three of those cases, Norwich Pharmacal relief granted in support of foreign proceedings, although the observant amongst you will note that the dates of those three judgments will predate Ramelos. So I think it's fair to say in the Channel Islands and the Isle of Man, it's not quite clear whether they will follow Ramelos or chart their own course. K versus Z is a more recent decision of the BVI High Court. Again, in the BVI, there is a statute that is almost identically worded to the 1975 Act, but the BVI High Court declined to follow Ramelos. And the reason was essentially that there was nothing in the legislation to suggest that the BVI legislature wanted to confine the ability of BVI courts to aid foreign courts in doing justice. And Mr. Justice Wallbank, who's the judge in that decision, has a policy explanation for his decision that is very much in keeping with the sentiment that Sir Jeremy Cook expressed in the DIFC about the importance of international courts at the, that are at key financial centres, assisting other courts in doing justice. And the BVI have now, in an amendment in 2020, put the ability to obtain Norwich Pharmacal relief in support of foreign proceedings on a statutory footing. So there's no doubt now in the BVI. And an interesting one to finish on, SR Global Fund, that's the Court of Appeal of the Cayman Islands. They also declined to follow Ramelos. They also have a statute in the same terms as the 1975 Act. What is particularly noteworthy about the Cayman Island decision is that two of the three Court of Appeal judges were ex-English Court of Appeal judges, Sir Bernard Ricks, Sir John Goldring. So across the common law world, you now have two former English Court of Appeal judges, one former English head of the Commercial Court, who've all said, we're not sure that Ramelos is right. So it's been a fixture, Ramelos, of the last decade of my practice at the bar. It remains to be seen whether it survives the next.
Thanks, Matthew. That's the end of our session.